Right, okay, pitchforks and torches at the rally. I'm the
CFP audiences are very cool.
I'm the boogeyman on the panel, as you've gathered, and what I really want to do is to briefly take this right back to brass tacks and think about what are we trying to do here, why I consider that the intermediary has a role to play in internet content being regulated, why I'm not a fan of the Section 230 approach, and what I would see as the way forward, certainly from a UK-European perspective. Now, ultimately, as I say, the bottom line here is we're trying to protect freedom of expression. So the question for me is, how does the nation state regulate our freedom of expression? And the obvious thing to me, it seems, with freedom of expression is that the law is not so much, in effect, saying, here's all the cool stuff you can say. It's saying, look, here are the limits. It's less explicitly spelled out in relation to the First Amendment in terms of the First Amendment itself. But in Europe, we come under the Convention on Human Rights, which has Article 10.1, which says, hurrah, we've got freedom of expression. And Article 10.2 explicitly says, oh, careful now, don't get carried away here. And one of the limits it specifically refers to is protection of the reputation of others, amongst other things. Now, so think about it from the perspective of a nation state that says that we want to protect freedom of expression on the internet, but we want to do that by enforcing our limits, where we say there are legitimate reasons for limiting freedom of expression. Now, obviously, the problem we run into is that the internet is a global thing. I upload content here in Washington, it's automatically available globally, whether it's legal or not globally. And so many areas of content, we have vastly differing laws from state to state. So, between the Holocaust denial, we saw that with the Yahoo case about 10 years ago. Even something as relatively uncontroversial as child pornography, we have all these different detailed issues everywhere as to, well, hang on, this is what this is actually about. And even, on the civil liability side of it, libel, we have these tremendous variances as people, certainly from this side of the Atlantic and within the UK, who have railed against supposed libel tourism in London would point out. So, there are a number of ways we can approach unlawful content generally. You either go for the source, the person responsible for it. Problem with that, of course, is it's not always easy to trace them. It may be impossible to trace them. Even if we do, they may be protected by local laws, jurisdictional difficulties. So we can try going for the end user, kill the market, and therefore kill the motivation to make the content available. That's been done in the UK in relation to certain categories of obscene material, when they criminalise possession for that very reason. Again, you're dealing with hydra heads rather than the root cause of the problem. And it seems to me that what we then logically have to come to is to say, well, if the intermediary is in a position, very often in a position to control the content that's there, be that libel or whatever, so it would seem to me logical that they have a role to play. So how do we play that? Do we put legal liabilities on them? Do we immunise them from liability in the hope they'll play Good Samaritan? How do we approach it in China? They effectively employ the intermediary as more or less an agent of the state. You have to get a license, you have to sign up to all sorts of blocking and filtering things, and you promise there's certain types of content that you block out that the Chinese constitution decides, hang on, this is where we draw the limits of freedom of expression. And, technical blocking is, I'm sure you've all had that argument ad infinitum, it doesn't really work. It's obviously that's not an approach that we would find acceptable here, and applying it to elements of civil liability, but particularly the libel, it doesn't fly with that. And of course, course, it would be in any attempt to bring that in. The US has been thrown out on First Amendment grounds anyway. In the UK, we've had some of it has been used in certain contexts on a voluntary basis with the BT Clean Feed system that ISPs sign up to. But the problem has been there, this question of accountability, because you've got an intermediary deciding, hang on a minute, I'm going to decide whether or not this is legal rather than a court. I'd come back to that specific point in a bit. So the main alternatives, as I said, coming in are you either go for a notice-based liability type system like you have here under the DMCA, or we have more generally in Europe, because of course we have a single uniform system that applies to all unlawful content equally, or you have this sort of immunised type approach. Now, the immunity under the CDA, as we've already heard, is incredibly broad. It covers not only hosts, it also covers people who run websites. Schneider and Amazon were protected in relation to the book reviews that were put up with the of Schneider's books, and indeed of Schneider himself. Barrett and Rosenthal in California, the California Supreme Court said this protects a user in the instance where somebody simply hits the quote button and republishes somebody's statement. Now, a very broad immunity. It seems to me that in part we can see the law of unintended consequences coming in here. And what I mean by that is that the original point of Section 230 was it wasn't only here's some freedom here are rights to a way of avoiding liability, but there was also it was allied to the distinct provisions which of course the Supreme Court threw out in relation to making pornography available to minors in case our kids saw it and grew up and become rapists. And they were so it was balanced out by these responsibilities as well, or at least by a sense of responsibility being engendered, encouraging the ISPs to actively edit their servers for certain types of undesirable material. And it seems to me that that's not the way it's gone. It has become sort of a monolithic defense that basically says, well, you're not liable, therefore we don't have to do anything. And it seems to me, coming from our European perspective, that it's entirely appropriate to say, look, you hosted illegal stuff, you clearly knew it was illegal, therefore you should bear some level of distributor liability. If they knew it was there and they did nothing about it. Now, the difficulty with notice-based liability is particularly in the civil context, I'm thinking particularly about libel as a comparative to Section 230, is that it's not only actual knowledge of unlawful content that's enough, it's also constructive knowledge. So the directive says, you're entitled to a qualified immunity from this and you'll not be liable for hosting it if you are not aware of facts or circumstances from which the unlawful nature of the content is apparent. Now, on the plus side, it seems to me it allows for liability where, which I think is appropriate, where an intermediary has clearly either deliberately or negligently allowed blatantly unlawful material to carry on being available. On the flip side, and this is, I recognise the difficulty, and there's been a lot of discussion about the chilling effect, so-called, the idea that an intermediary is approached and somebody says, I own the copyright in that, or that defames me, or that's obscene, or whatever, and they decide, right, we're not risking being liable, down it goes. Now, I've talked to a number of UK ISP players about this, and actually most of them do make some reasonable effort, and they've all indicated they make some degree of effort to actually determine whether or not the material is unlawful before they take it down. The difficult one being, of course, libel because of whether they know something's true or not. Now, okay, so how do we address that? And that's always the big one that the pros Section 230 can't in effect fix on as the problem for notice-based liability. So it seems to me there are two options. I could either give in and say, right, let's go with 230. Not going to happen. I can't get my head around this idea of, just creating a situation where somebody is able to say, I don't care, I'm not liable, therefore I will do nothing, even though I'm clearly aware of this being unlawful. But I think notice-based liability needs something more as well. So the chief options, as I say, are we either go with some sort of an adaptation of the DMCA reposting provision type approach. And this has been discussed. We are currently in the middle in the UK. Last week, the Minister of Justice closed the responses for their consultation on a new draft defamation bill, which and the consultation in particular asked a lot of questions about this element of service provider liability, and they said, look, we could go for a DMCA style thing with a set procedure for notification which allows the ISP to step out of the picture. I think that's logical. It's one approach. The other option that is being promoted, which I have a lot of sympathy with, would be to say, look, the intermediary is not liable until the court has declared that the information is unlawful, and then at that point, if they do nothing about it, with the court's guarantee that it's unlawful, therefore the decision taken out of their hands, then they become liable at that point. Now, what they have to address with both of those is how do we do that in a way that's reasonable about cost. And while I don't share the opinion of some of my colleagues in the UK that cost is the only problem with English libel law, certainly those would both involve going to court. They can be expensive approaches, but part of the debate that we're having on libel, which would feed into this in the UK certainly, is that whether we create or how we create a low-cost tribunal where libel cases will go, changing the law so that instead of it being decided what a statement actually means for libel purposes, way down the track when you actually end up at trial, that being decided right up front and early on. And it seems to me that would dovetail with this approach, allowing the balance between not putting the ISPs in a situation where they will just automatically decide not worth the risk, take it down, and thereby chilling free expression, but equally creating a situation where a distributor, be they a bulletin board operator, be they a host or whatever, can reasonably be held liable where that is appropriate and in the interest of justice so to do. I think that's about where I leave it. And